Good afternoon, and thank you for those who are joining us today from Zoom and from YouTube. I am Presti from the External Economic Relations Division at the ASEAN Secretariat. I will be your host today as I will guide you throughout the sessions. So today is the fourth of our webinar series on unlocking Rsap for business, which are focusing on investment, intellectual property, and the e-commerce chapter. This webinar is in collaboration with the East Asia Business Council and as part of our efforts to promote and create awareness on RCEP chapters. The first session today, we will consist of 3 presentations, which will focus on investment and screening regime and dispute settlement, and then to intellectual property and e-commerce. But before we begin, we will have now Mr. Lee Kwang Lan, Director of Market Integration Directorate, to deliver opening remarks. Mr. Lan, you have the screen.
Thank you very much. And distinguished speakers, panelists, participants, and ladies and gentlemen. So it is my great pleasure to welcome you on the 4th round of the RCEP webinar series. As we will start implementing the RCEP agreement from the 1st January next year. Actually, that is about 2 weeks from now. The webinar series holds more importance than ever. For the agreements to serve its purpose, we need to make sure that businesses in the regions, particularly small, medium-sized enterprises, fully perceive how to utilize the agreement. For that purpose, the ASEAN Secretariat has been in partnership with the East Asia's Business Council to embark on a public outreach campaign. So this endeavor has been supported by trade and investment experts, and most of them are very much involved in the previous negotiation process. And we are joined today by a great deal of speakers that will cover 3 key elements of the agreements: investment, intellectual property rights, and electronic commerce. So, ladies and gentlemen, the entry into force of the Rsap could not come at a more opportune time as we are treating the path to recovery from the pandemic. The implementation of Rsap should be able to accelerate the economic recovery process by creating business opportunity and employment for the people in the regions. But how exactly the Rsap contribute to that endeavor? Let me start by sharing with you some of the economic statistics out of the COVID-19 pandemic. The ASEAN response measures and their result impact. So last year, ASEAN economy witnesses a contract of 4.4% in terms of GDP. Our merchandise trade fell as much as about 5.5%, and the inflow FDIs in the region dropped by about 25% on a year-by-year basis. That is really a significant downfall in our economic growth. However, this year we have seen the early sign of the economic recovery based on the most recent data we collected from the ASEAN Development Bank. The ASEAN growth is expected to achieve about 3.1% growth this year, 2021. And next year, it projected to achieve about 5%. So now that is really the thing that we all need to put our endeavors, maximizing the potential of the intra-ASEAN market and the broader economic integration has been identified as one of the exit strategy under the ASEAN Comprehensive Recovery Framework. Now, with the entry into force of the Rsap into play, the post-pandemic recovery plan require more trade and investment, and no less. So the Rsap can contribute to this purpose by creating an enabling environment for the business to do your transaction throughout the regions. On this note, let me highlight some of the main elements in the investment, intellectual property right, and e-commerce. Now, first, investment. The Rsap is aimed to creating an enabling investment environment by installing protections, more liberalization, promotion, and facilitations. The agreements would accord fair and equitable treatment and full protections and security to all investors in the regions. In addition to that, investors from any one of the parties will not be subject to any performance requirements as the conditions for entering and expanding and operating your business within the region. On the intellectual property rights, the business are able to enjoy more protection than ever before, as long as the parties are required to ratify and accede to some of the key multilateral agreements relating to the protection of the intellectual property rights, including the Paris Convention, the Berne Convention, the WIPO Copyright Treaty, among many others. So this is really a big upgrade from the previous ASEAN Plus FTAs, including the UNFATA. On e-commerce, the Rsap encouraged all parties in the region to improve trade administrations and process by promoting paperless trading and recognizing electronic authentication signatures. The agreements also require each party to adopt and maintain a legal framework on the online consumer protection, personal data protection, unsolicited commercial electronic message, transparency, electronic transaction, cybersecurity, and e-commerce custom duty. But in realizing these potential benefits, we depend on the effective implementation at the national level, and also it depends on how the private sector really perceive and utilize it. So, ladies and gentlemen, let me conclude my remark by highlighting key question is, the key issue is, the Rsap is an integral part of the long-term sustainable economic recovery of ASEAN and the region. So we should treat the path to the recovery with both optimism and resilience, so that together we embrace a better opportunity and brighter future. So with that, thank you very much, and I wish the webinar successful.
Thank you, Mr. Lan. Now, I know we are all excited to listen to our key presenters, but before going to that session, I would like to invite our speakers and panelists for a short photo opportunity. May I request for our speakers and panelists to turn on the camera, please? Okay, so on my remarks, 1, 2, 3. Okay, one more session. 1, 2, 3. All right, thank you very much, everyone. Just some house rules. All participant camera and microphone have been disabled, but should you have any questions throughout the session, please use the Q&A box, and we will be able to answer after the panel discussion. So without further ado, may I now give the screen to Attorney Marjorie O. Ramos Samaniego, the Director of Market Integration, Ms. Ati Ramos Samaniego is Ms. Ati will be presenting on the investment chapter of the RCEP Agreement. Ms. Ati, you may now have the screen.
Thank you, Ms. Presti. Thank you for inviting me. Good afternoon to all. Allow me to present to you Unlocking the RCEP Investment Chapter for Business. So as the RCEP Agreement, as everybody know, was signed by the Trade Minister from the ASEAN member states, plus Australia, China, Japan, Korea, New Zealand on November 15, 2020. This is in the midst of the COVID-19 pandemic. Presti, may I ask for you to share the PowerPoint presentation? There. Okay, thank you. Maybe you could have it in full slides. Okay. So the objective of the RCEP, as stated by Mr. Lan, is to establish a first slide, please. First slide. Could you, yeah. So the objective of the RCEP agreement is to establish a modern, comprehensive, high quality and mutually beneficial economic partnership that will facilitate the expansion of regional trade and investments and contribute to the global economic growth and development. So this agreement aims to bring about market and employment opportunities for businesses and peoples in the region, and it provides for an open, inclusive, and multi-based, multi-trading system. And if I may add, hopefully the RCEP agreement will foster the economic recovery of RCEP parties from the wrath of the COVID pandemic. So let me now unlock to you the investment chapter. Next slide, please. Okay, so the investment chapter covers, my presentation outline includes, first will be the 4 pillars of investments. Then I will talk about the negative list to annex approach for us to be able to navigate the schedule of reservations. Next slide, please. Okay, the RCEP investment chapter covers the 4 pillars of investments. It covers, as you can see, from the pre-establishment phase to the post-establishment phase. And what are these pre-establishment phase? First is promotion of investments. Then we'll talk about facilitation of investments, which are both on the pre-establishment of an investment. Then the protection features that will be provided to RCEP investors and investments. And we will talk about liberalization. Next slide. For the promotion of investments, the RCEP parties agreed to increase awareness by encouraging investment in each other's territory. It includes organizing joint investment promotion activities between or among the parties. It will promote business matching activities, and there will also be support briefings and seminars on investment opportunities in each other's territory, and there will be conduct of information exchanges. And for the facilitation of investment, it aims to create the necessary investment environment. And how would that be done? There will be simplification of procedures for applications and approvals of your business permits, registrations, among others. There will be dissemination of investment information. So this will include the laws, rules, regulations, policies, and procedures of each parties. And of course, there will be an establishment of contact points for assistance and advisory services. For the Philippines, you can simply go to the BOI. We have a one-stop action center, and at the same time, you could also visit the BOI website for the portal on any assistance and advisory services. So this will be made available. Each member state of Rcep will have all of these contact points for easy access of investors through the business regulations of each member party. Next slide, please. Now, this is a very important element now for the investments, which was negotiated amongst Rcep parties. What are these protection of investments? The protection of investments would come post-establishment. That means to say that when you infuse your investments will be protected. And what are these? First is national treatment. What does this mean? This simply means that investors and covered investments shall be accorded same treatment as that of host countries' investors and covered investment. So let me just illustrate it. For example, there are a lot of ASEAN member states that allows manufacturing for exports. And when you say national treatment, foreign or local, they're allowed 100% equity participation. So that's national treatment. And if there are export requirement imposition, like for example, 50% or 60%, the same applies to both local and foreign. So there's no discriminatory treatment between a foreign investment and a local investment. Then next, another is very important protection is most favored nation treatment. This simply means that investors and covered investments of a party, Rcep party, shall be accorded the same treatment with any other party or non-party. So to cite an example, for example, the processing period for you to secure your certificate of registration is 3 days. The same applies to the local investor. The same applies to any other party, any other Rcep party, whether it's Japan, Australia, or any ASEAN, or even with non-party, US, for example. So you are given the most favored nation treatment. Another protection is the treatment of investment. For the treatment of investment, it covers 2 material elements. Your covered investment will be accorded fair and equitable treatment, and this means to say that you will not be denied due process in any legal or administrative proceedings. This means that the host Rcep party will accord to you all legal or access to legal processes before courts, administrative tribunals, or any bodies with quasi-judicial functions. Then another is a full protection and security. Your investment will be provided with measures that will ensure the physical protection and security of such covered investment. And how will this be done? This simply means that whatever police protection that is given to domestic investments, the same will be accorded with an Rcep covered investment, a covered investment of an Rcep party. So that's for full protection and security. Next slide, please. Okay, as stated, Mr. Lan stated about non-imposition of prohibition of performance requirements. So this means to say that when you place your investment in a member in an Rcep party, they cannot, as a condition for registration and post-establishment, impose measures such as trade balancing requirements, domestic content, export controls, or transfer of technology. So if you set up a manufacturing manufacturing facility in the Philippines, for example, there will be no imposition of transfer of technology. That is an example of which. But I have to state that there are reservable obligations, which includes the national treatment, the most favored nation treatment, and the prohibition of performance requirement, and the senior management and board of SMBD, senior management of and board of directors, but that will be taken care of in the liberalization. I will explain that to you later. Okay, another protection element is transfers. This allows you free transfer of your capital or your profit or repatriation of profit or any interest into and out of the RCEP party's territory. So it's literally a free transfer. There are certain exceptions, of course, such as payment of taxes before you could repatriate, or if you have an obligation in any judgment by courts or administrative bodies, then you just need to pay it. But otherwise, if it's clean, then you can simply transfer your capitals, profits, and anything, provided that it relates to a covered investments. Then another very important protection feature is freedom from expropriation. So your investment is free from any expropriation or nationalization. There are exceptions, of course, except for a public purpose, in a non-discriminatory manner, and upon payment of a compensation and in accordance with the due process of law. Next slide, please. So another protection feature of the RCEP investment chapter is compensation for losses. What does this mean? This means that covered investments owing to our losses of covered investments owing to armed conflict, civil strife, or state of emergency shall be accorded the same treatment as that of the host parties' investors and their covered investments or investors of any other party. So for example, there is, you incur a loss owing to war, for example, and that RCEP party have compensated its domestic investor because of such war, then automatically RCEP party's losses as well owing to that war will also be compensated. Then another feature is subrogation. Subrogation is a recognition of subrogation or transfer of any right or claim with respect to covered investment. Subrogation happens when an RCEP party pays an investor under a guarantee or contract of insurance in respect of a covered investment, in which case the RCEP party that paid takes over any right or claim of the paid investor, such that that paid investor can no longer pursue such right or claim unless duly authorized by the party that pays it. Next slide, please. Okay, now we go to liberalization. This is one important feature that the RCEP investment chapter has that all the other ASEAN +1 agreements do not have. So what is liberalization? Liberalization allows a transparent mechanism for investors of RCEP parties to determine the areas of investment that are open, or if you want to look at it the other way around, that are closed or partially open or partially closed to such investors and investments of RCEP. I will explain it to you when we go to the example, but okay, you can find this in the schedule of reservation or non-conforming measure, and you would see there that under the schedule of reservation or non-conforming measure, this is simply a listing of all existing non-conforming measure that are not in full conformity with national treatment, most favored nation treatment, prohibition of performance requirement, and SMBD. And for existing non-conforming measure, this will be listed in list A of Annex 3. Then you also have list B, where these are measures that a party adopts or maintains, such that the NT, MFN, PPR, and SMBD will not apply. Next slide, please. Okay, negative list to annex. I'll just give you a preview of what is list A and list B, such that it will be easier for us to navigate an Rsap party's schedule of reservation. As stated, it is very important for you to know the schedule of reservation or the non-conforming measure of a party. Why did I say so? Because, for example, if you intend to go into the manufacturing sector of the Philippines, for example, then all you have to do is what are the reservations with respect to the manufacturing sector. Whatever those sectors or subsectors or industries that are not listed in that schedule of reservation, that means to say those sectors, subsectors, or industries are open 100% for foreign investments. So list A, again, I just have to emphasize this. These are listed measures, existing non-conforming measures that will not conform with these reservable obligations, the 4 reservable obligations, NT, MFN, SMBD, and PPR. I have to state though that in Rcep, there are several parties already that adopted a joint schedule of reservations or non-conforming measure for both investment and services. So other elements may be added to this, like local presence or market access, and these are basically falling under the trade in services. And that's for list A. So what does this mean? This means that whatever is placed, the description of measure there, whatever undertaking that is placed there, they will not be made more divergent in the future. List A then provides for a standstill commitment. So whatever existing legislation you have that is listed in list A, you cannot make it more restrictive, more divergent. So it's locked. That measure is now locked, and you can no longer remove it, or you could amend it, but only make it more liberal. And there are also some parties in Rcep where they also committed Ratchet Mechanism. What is this? What does Ratchet Mechanism means? It means that if there are unilateral liberalization, I'll explain it to you later when we go to the examples, then that further liberalization shall automatically be bound. You don't even need to have a protocol to amend your Rcep commitment. It will automatically be the more liberal measure will already be bound, and that will be also be locked. So that's for list A. That's why it's very important for you to navigate the schedule of reservation for us to understand how to really get into the sector in each party's agreement. And it's transparent because you could see the sources of measures. Now, what's list B? Of course, there's nothing absolute in this world. What is provided here is that the obligations of NT, SMBD, PPR, and MFN as applicable will not apply to the agreement. So this is where these sectors are being reserved by the government such that they could change it unilaterally because of the sensitivity of that sector. Typically, these are defense-related or securities. It has to do with the security of the country. Those measures are provided for under List B. However, under the List B of an Rcep member party, the list cannot be expanded once you have committed that. So whatever sector is closed and it's placed under List B, you cannot add another sector or another industry. So it's also locked. And I have to state that when we were doing the listing, List A and List B, the schedule of reservation of each member party, of each Rcep party, is highly negotiated. So to the extent possible, the Rcep parties are given really a more favorable treatment in terms of liberalization. Next slide, please. So now we go to how do you navigate the schedule of reservation. Okay, here I will show you the Philippine reservation. It's list A and it's number 10 in the schedules of reservation. The sector here, for example, is manufacturing. Okay, list A. So as stated for list A, this one is subject to standstill commitment. So it cannot be made more divergent, whatever is listed here. If there are partial allowing foreign equity participation, then it is locked in there. So that's when you talk of list A, that is what it means. And sector here is manufacturing, level of government, so all levels, which means from national to local. And what are the types of obligation being reserved? We have where NT, MFN, Prohibition of Performance Requirement, SMBD. And what do we have here? The measure is the processing of the following products is limited only to Filipino citizens or corporations, associations, at least 60% of whose capital is owned by Filipino citizens and subject to compliance requirement terms and conditions. What are these? These are typically mineral products. So it emanates from mining actually, but it falls under manufacturing because it goes into the processing. It talks of copper wires, copper bar sheets, strips, brass, bronze, and other alloys of copper. And then nickel, pig iron, and ferronickel. So this means to say that if you would like to see what is allowed for foreign investments, 40% foreign equity participation is allowed. What is allowed for senior management and board of directors, 40% of such can be allowed to be board of directors. Maybe there are certain prohibition of performance requirement. Maybe you would be required to employ Filipino citizens. Those are things when you say that there are reservable obligations. So that's for the first reservation. Can we go to the next slide, please? Okay, for example, again, another reservation of Australia. It's list A number 2. So list A meaning to say this is a standstill commitment. It covers all sector. What is the level of government? Regional. So it did not cover its national or state, federal or state, I think they call it. This one covers the regional, which means that what they are reserving is the local, regional or local in some jurisdictions. It covers several type of obligation, NTMF and local presence. Okay, you have their local presence because their reservation here covers both the trade in services and investment. That's why you have local presence. And you also have PPR or Prohibition of Performance Requirement, and then SMBD. And what is the description of measure? All existing non-conforming measure at the regional level of government. So it covers only those that are locked in, the existing. Anything on existing non-conforming measure that may be in violation of all of these 5 obligations, then they can actually do it, okay? But this is limited to the existing. Next slide, please. Okay, another example is Thailand, for example, for their fishery sector. For their fishery sector, the reservation is level of government, all levels. So it goes all the way from national to local. And then the type of obligation, NT, national treatment only. So what's the measure there? It's NT because here they stated that foreign equity participation must not exceed 51%. And since it's fishery, they talk about culture of tuna deep sea cage and indigenous breeding spiny lobsters and all of these types of fishes here, which this means that the Rcep member states or Rcep parties can actually invest 49% in fishery sector for all of these types of fishes in Thailand. So assuming that Thailand failed to list this, if Thailand did not list this, then it means to say that it is open. It is open. But since they listed it and the fishes here are very specific, then 49% foreign equity participation is allowed. All of those types that are outside of this may be allowed, unless, of course, it's listed in another listing. That's why I said that when you look into a schedule of reservation of an Rsap party, if you're interested in fishery, then look at all their reservations with respect to fishery. Next slide. So here you would see Thailand's reservation for List B. What does List B mean? List B means that national treatment, MFN, PPR, and SMBD will not apply, such that they can amend it. They have the right to modify the measure. And if you would look here, essentially what they are saying here is that for you to operate a business in Thailand, you have to obtain a certificate from the Department of Business Development and to comply with whatever conditions provided there. But you would see here that they have a minimum capital requirement of, the minimum capital requirement here states that in no case shall be less than 3 million baht. So while there is a minimum capital requirement imposed here, but since it is under List B, then that means to say that Thailand can modify this. It can increase it or decrease it as it deems so, because List B provides for policy space for the country, for that RCEP party. Okay, next slide, please. Another example will be Malaysia. Here you would see that the sector being reserved is about mining and quarrying, and it's very specific to oil and gas. And what are the types of obligation? It covers national treatment, market access. Again, market access because Malaysia's schedule of reservation or non-conforming measure covers already both trade in services and investment. Okay. MFN or most favored nation treatment, local presence, prohibition of performance requirement, and SMBD. In short, the types of obligations being reserved are all the reservable obligations. And what's the measure here? It provides that Petronas and its successor are vested with the entire ownership in and the exclusive rights, powers, liberties, and privileges which shall be irrevocable in exploring, exploiting, obtaining petroleum, whether onshore or offshore of Malaysia. There's another statement here on the measure. Petronas and its successor reserve the right to adopt or maintain any measure relating to the oil and gas upstream industry, including related activities. So here, it just goes to show that anything on exploration, exploitation on petroleum, onshore or offshore, relative to oil and gas, since it's under List B, Malaysia have a policy space there, and it will not, these reservable obligations will not apply. But I have to state again that all other areas that you cannot find in the parties, in an RCEP party's schedule of reservation, that means to say that that is open for foreign investments. So in short, if it's not listed, then it is open for foreign investments, and any foreign investor coming from an RCEP party are welcome to invest in such sector, industry, or subsector 100%. That's how you read the schedule of reservations of RCEP. Next slide, please. Okay, thank you so much for listening, and I'm ready to take your questions later. Thank you, Presti. Rusty, back to you.
Okay, thank you, Attorney Marjorie, Governor of Board of Investment Philippines. Now, for the next speaker, we have Ms. Mary Elizabeth Chilea, the Principal Trade Specialist, Singapore Ministry of Trade and Industry. Ms. Liz will talk about the intellectual property chapter under the RCEP Agreement. You may have the screen, Ms. Liz.
Thank you very much, Presti, for the introduction, and good afternoon to everybody. As Mr. Kwan has already said, in most of the ASEAN agreements and the +1 agreements, there's been not very comprehensive coverage of intellectual property. So let me take you through why IP is important and why then the RCEP IP chapter is something that would help us have the common rule book that will help RCEP parties really mitigate and benefit from this chapter as they navigate the new trade world that is emerging, because we are seeing so many new initiatives in relation to medicine, in relation to innovation for sustainable trade, renewable energy. So this is where hopefully the RCEP IP chapter will help all of these innovators and producers then take advantage in the RCEP region. So just a brief background, what is intellectual property? It's a category of property that includes intangible creations. You know, you cannot really touch most of it, except maybe the creation itself, if it's like a motorbike or a motor car. But usually you look at it as your trademark, your copyright. In fact, even this presentation that we are doing today can be copyrighted and nobody else should be able to steal it. So, you know, it's this sort of intellectual property. It has an economic value because it enables people to earn recognition or financial benefit from what they have invented. And so the trick about having an IP chapter is how do you balance this financial gain between what is the wider public interest? So there are actually two key areas for IP, economic and social, where you support investment in innovation and R&D activities, the new phones, solar panels, things like that, which, you know, you're encouraging pharma, especially now with COVID, all the test kits and everything that's coming out, all will be, you know, being protected by your patent. And then the brand that's related to that, because there's a reputational aspect. And the creativity, you know, during COVID, we have also seen a lot more creativity digital-wise, you know, so many things are there. So how does that, is that protected as you go forward, because you don't really want other people to steal your creativity as well? And then the social political aspect is finding a balance between the rights holder and the consumer. So for example, you know, there's a lot of discussion on pharmaceutical patents. Pharmaceutical patents could make it very expensive for us to get the right price for the drugs that we need now to combat COVID. So, you know, how do you find that balance? What sort of exceptions do you give? You also have issues on agriculture. You know, many countries have a socio-political interest in protecting their green lung, all the forests and everything. And so as you do that and people want to come and, you know, say that, oh, but maybe this plant is very good in having a medical protection, so I want to patent it. So how do you find a balance so that your original inhabitants can still use the product and yet the innovators can also be protected? So there's a lot of debate these days, especially on this socio-political nexus, because many people unfortunately have seen IP in a negative light. They equate it to big business, taking away the rights from people, but this is not really the case. IP actually protects the small business much more than the big, because you are there starting fresh. You don't want anyone to steal your ideas. And if you do your IP protection correctly, this is how it's going to set you on the road to success. I'm not sure whether you all remember, you know, there are some movies where they feature Hugh Grant, for example, all he did was come up with some jingle for an advertisement, and then he's always getting the royalties from the jingle. So, it's a small thing like that which IP helps protect you and give you economic gains going forward. So then what are the usual type of intellectual property that we deal with? So patents, which we talked about quite a bit, protection of the invention. There's a lot of stories also now going around about those who patented the seat belt, how, they did not collect the royalties for it, how they gave it away so that all auto companies could use the invention, so balance against new inventions that are coming today. So this is a social political, am I going to keep it in place? Am I going to give it away? But before you do anything on this, you still need to register and ensure that it is something that is registrable. Designs is, the curve of the car, how your chair is designed, your table, these are all registered designs, and you can protect it as well. Geographical indications, is more common, so basmati rice, kampot pepper, some of these are some of the things which are geographically protected, so that you make sure that if somebody cannot use the name, because it comes with a certain expectation of taste, flavor, and you don't want other people to take that away from you. Then, of course, we have copyright, which is the most famous, protection of your movies. I used to say during the meeting, the Sandiwara and everything. So it's not just the foreign protection, it's your own creativity from your own country that you also want to protect. It's not always protecting something which is foreign. And I think this is what I would stress. Many in ASEAN sometimes do not really think that through. They think that if they're doing a lot of IP protection is to protect the foreign, forgetting that as we are all rising in our economic development, you're actually doing more good for your own business than from the foreign business as well. And confidential information is like some trade secrets like the Coca-Cola formula, the KFC formula. Maybe later on we have some local delights formula which will also be protected. So this I've borrowed from my intellectual property office because I thought it's a very nice way of just showing you what is registrable, what is not needed to be registered. And this just keep in mind as you go through the IP chapter, because it is very complicated and complex chapter. So I'm trying to, just give you a brief overview so that those who are interested will pay a bit more attention in going through the chapter. So let me just start again. Innovation is what we're all promoting throughout the entire, especially ASEAN region. So you're promoting innovation, generation of ideas. So it's not just in terms of what you're manufacturing, but what you're creating, your books, your movies, your songs, everything, then how you can be protected and how these are then going to be revenue generating. So in some IP circles, they are started to be referred to as intangible assets, which go into your profit and loss statement. So this is something then to bear in mind from the economic aspect. Why do you want to pay more attention and how you register and protect your intellectual property? So this all first started at the WTO with the TRIPS agreement. So the TRIPS agreement is the most comprehensive. It plays a central role and is the common rule book. So you know what sort of protection you can do for copyright, for patents. But TRIPS is old. It came into force in 1995. The world is so different today from 1995. That, when we did it in 95, the internet, all these, and now with COVID, all these digital work streams are going on. So the TRIPS may not adequately deal with all of these protection. But, before we go on to say what else we need to then see it, you need to just first remember that IP is territorial in nature. It's part of your domestic legislation. And when you apply it, you will not apply it just to your FTA partners. So in that way, it's a bit different from investment, which can be, who else? Only the FTA partners will benefit from what you're opening up for trading goods, for trading services. But intellectual property, because it is territorial aspect. So even once you improve your IP system, it doesn't mean that only the RCEP parties will benefit from it. So the question then is, why would you want to do it when you're going to have some sort of free rider? So when you're negotiating the agreement, you're going to negotiate what works best for the 15 parties. What is it you really wanted to see within the 15 parties to enhance trade and cultural relationship, economic development amongst the 15, especially in terms of protection and enforcement? So TRIPS sets a level playing field. And then the World Intellectual Property Office, WIPO, then has been going on since 1995 to come up with a lot of other intellectual property instruments. So one advantage for us when we are doing IP chapter and FTAs is that we do not need to negotiate the rules from scratch. You know, we can borrow, sort of like buy off the rack in a way, by buying off and taking off what WIPO has already developed, so long as the parties to the FTA agree that, yes, this is something we all want to have as enhanced protection, and let's all agree to it. And so we just say we are going to adopt the Patent Cooperation Treaty, the Madrid Protocol, or the Hague Agreement. These are just some examples that, you know, FTA partners then adopt in as part of their FTA commitments. So just a brief overview again, TRIPS agreement covers all of these issues. WIPO covers, and these are the most common WIPO agreements that we will see being adopted into FTAs such as Rsap. So why IP is gaining importance in FTAs? FTAs, as you know, is an economic agreement. It's not really a social agreement. So although there's that social balance, there's more and more interest in putting it into FTAs because you want to protect additional IP rights that the earlier TRIPS agreement was not covering to a certain extent because, you know, as I said, it's old, it's from 1995. So as we go into the new area, we are going to see what is it that you want to do to protect your newer IP rights that are coming up, the ones in the digital, the broadcasting, the copyright areas, your furniture design. For copyright, how are we extending it into different areas? For trademarks in the WTO TRIPS agreement is mainly for visible trademarks, you know, your logos, but then now we are moving into scent marks, sound marks, you know, your Nokia ringtone. It is a trademarkable effect. If you go into certain shops, you know, as soon as you enter the shop, you smell the fragrance, or may not even be near the shop. So Shanghai Tang is like that. You know that there's a Shanghai Tang around as long as you enter the mall and you can smell the fragrance. So that's also something which is new and not covered under TRIPS. So the main thing is, so because we are seeing it as being a revenue thing, so you need to have greater IP protection. So protection enforcement then becomes very, very important because even as the previous speaker talked about it in investment, you do not want to have forced tech transfer. You do not want to lose your rights as to what you spend years over inventing and, you know, spreading out just to be stolen by someone else, you know, by someone, just because you want to invest and they say, okay, only if you invest, then you must let me have the IP. No. So this is where, you know, there's some relationship between the other chapters in the FTA and the IP chapter. So what though a minimum can offer, because it also depends on the different economic level that each party is bringing to the table, the different interests that everybody is having. There are some countries who are very keen, for example, to have a lot more protection for GMO products. There are some which are saying, no, then that will make it very expensive for my poor farmers because, you know, if you buy a GMO product, you have to pay for the patent cost of the seed. You know, so it's very different from just getting the seeds from your garden and repropagating it. So if your community is a bit lower in the poverty level, then you're not going to be so keen to add additional costs to your farmers in this way. So therefore, this is where the socio-economic element also comes into play. So key benefits, trademarks, trade secrets, copyright, patents. And so the common then features will be provide clarity on technical details in relation to registration is something which IP chapters really focus on. So for what we have done, for example, in Rsap, which I will elaborate a bit on later, is that you can have one common registration because we are adopting the Patent Cooperation Treaty. You are also thinking about moving towards electrical, digital forms of registration. This will make the life easier for businesses as well to check who else is also trying to register for something similar. So this is on the technical details of registration, very important and sometimes not paid enough attention to, because if you don't be very clear on this, you may lose your IP because IP is usually first in time registration. So we then identify which are the WIPO treaties that the FTA partners want to be part of because they say, okay, this is the common rule book we are all going to do to set the minimum standard for this agreement. And when it's a regional agreement, it becomes even more powerful because it means that all 15 countries are having the common rule book. So you have assurance to the businesses, even as they expand into any of the other 15 countries via the investment protection, that yes, as I'm there, I can still apply for copyright patent protection. If I already have the protection, it will also already apply, and how can I enforce it if somebody is trying to steal it? So this is where the last part, where I have a lot more enforcement remedies ranging from civil to criminal, and this is very important because UNSFATA and the earlier ASEAN agreements don't really touch on this in such depth as RCEP has done. So just to remind you, one of the main factors, because you're harmonizing your IP regime, so you know what you're doing is a one-stop filing system because we are adopting all these WIPO treaties, and it also then gives you protection, not as much as maybe, because you must remember that we finished the negotiations pre-COVID, and so we didn't realize how COVID would just enhance the entire digital environment, how you can do almost everything digitally today. So maybe that's one area that, upon implementation, we can also review to see what else we need to do. So again, a recap. So the RCEP IP chapter is actually one of the longest chapters in the entire FTA. It consists of 83 articles divided into the following sections: copyright, general trademark, GIs, patents, industrial designs. So this is just an overview about what it covers. Many people have also then talked about how ambitious is the RCEP IP chapter. So, some people like to say that, oh, because, it's from this region, so maybe it's not as ambitious, especially since, to be fair, neither ASEAN nor the +1 agreements have really gone into that much depth into IP issues apart from UNSFATA. So I've done a very basic comparison to show you all that actually the RCEP IP chapter is a very ambitious chapter. It covers similar issues that we have in PPT. In fact, in some areas, it goes a bit more, for GRTK, because we have more parties involved in RCEP who are interested in protecting their genetic resources, Indonesia being one of them. Then you have, so you can see almost everywhere, whatever we have in RCEP is also in CPTPP. There's nothing which is in CPTPP only except for RCEP, except for some procedural matters here, which actually is the other way around. So let me take you through in terms of some of the specific commitments to give you a highlight as to where the differences and similarities are. So, as I said, we buy off the shelf. That's the fastest way in an FTA to level up your IP protection, is you take something which has already been negotiated by WIPO, and then you say, okay, we shall all accede to this agreement, and then it will set up the level playing field. So you can see where the differences are. So, the Budapest Treaty and the Singapore Treaty are compulsory in TPP, but they are here, shall endeavor. So it doesn't mean that we didn't consider it. Shall endeavor means that any RCEP party who thinks that this is something that will help them, they are free to do it. We are not forcing them. Whereas for all of this, agree to ratify or accede to them means you have no choice. One of the most important things which reflects this social economic reality is that in RCEP, we have agreed to have everyone accede to a treaty that will facilitate access to published who are blind, published materials who are blind. CPTPP is a lot more economic focused and didn't have this. So this, through a lot of push by many of the RCEP parties, we have pushed to show that, we are also thinking in a non-economic benefit way as well, a way that will help your UN Sustainable Development Goals as well. So UPOF is a very interesting treaty because there are many in the RCEP region who are still very strongly agrarian-based with a lot of poor farmers. And so a lot of them then see UPOF as being an agreement which will add a lot of unnecessary costs to their poor farmers. And therefore, we did not manage to get it to be, you must, ratify it, unlike TPP. So you can see that, so almost everything which is in TPP is in RCEP, but maybe in slightly different categories. So just to remember that both FTAs have very high IP commitment levels in the role that it plays. Both FTAs also deal with non-traditional trademarks, and both FTAs also tackle the growing digital environment. This is, just now, sorry. Here, when I say we are going to do the copyright treaty, the performance, all of this also helps you as you move into the new digital realm because it allows for all of these protection. Both FTAs deal with border measures, they go and what, but most importantly is that both FTAs also seek to help business, since this is something that business is looking for as to how it will help them. So of course, we're trying to save costs by forcing one-stop registration systems because we have adopted the Madrid Protocol and the Patent Cooperation Treaty. So in one-stop filing, this means that instead of having to pay multiple filing costs and monitor it across the 15 Rsap countries, you can do it in one place, and it helps you get it done faster and be recognized. So in a way, it is business facilitating as well. Both also cater for electronic registration. Again, something which is becoming very important, almost all of us, and it's a good thing, I guess, now that with COVID and you cannot really move around freely. So this means that even though you cannot move around and, the IP office may be shut physically, you can still do all these electronic registration and checks because everything is now on an IT basis. So divergences, of course, exist because, there's different levels of development amongst the 15 parties. So Rsap has LDC members amongst our ASEAN member states. And so because of that, we have a lot more technical assistance provisions than CPTPP. This technical provision, though, will only kick in once the Rsap Ecotech chapter enters into force, because the members have to meet to decide how they're going to implement and take forward all these Ecotech technical assistance. What the IP chapter has is a whole list and the countries which have requested for this technical assistance. So it's like following the WTO trade facilitation agreement, where you put up what is it you want and then you wait for someone to help you. So hopefully, since, already good start by, is it the European, your partner which is helping you do all this, maybe it's also a partner that can help us look into how we're going to help provide technical assistance, especially for the LDCs. And then there are two different areas which I mentioned before where, because of the economic background and interest differences between Rsap and CPP parties, so UPOF was defensive, but there was stronger genetic resource protection interest. On GIs, we were about the same, except, because, we have parties in TPP that are also anti-GI, and they were also with us in Rsap. So because of that, you have found that the GI provision is very similar in Rsap to what we have in TPP. So at the end of the day, your IP chapter reflects what is it that the countries want to see in terms of protecting this new intangible asset, how you want to do the enforcement, because we have civil, criminal, and border. It's quite technical, so I have not really put it into the slides here. But it's something which, if you're, especially if the lawyers are listening into this seminar, should pay attention to as to how you can then help and protect your clients in their intellectual property enforcement and protection in those areas. So I've come to an end. I hope I've given you a bit of a deeper overview as to how this is an important deliverable that will also help us meet the ambition of, improving as we emerge from COVID and setting the common rule book, which makes Rsap a very strong FTA. Thank you.
Thank you very much, Ms. Liz, for the comprehensive presentation. Now, our last speaker is Mr. Budi Yuwono. He is a senior officer of the ICT and Tourism Division at the ASEAN Secretariat. Mr. Budi will provide an overview of e-commerce chapter under the RCEP Agreement. Over to you, please, Mr. Budi.
Good afternoon, distinguished panelists and attendees. I apologize for not having any slides because I was asked to be a panelist. So, but that is all right. I will provide some overview of the e-commerce chapters of the RCEP. The e-commerce chapter was added later in the course of the negotiations. It was added, I think it's the 10th round in the middle, 1/3 of the all rounds of RCEPs of all the 30-round negotiation. So the objectives of the e-commerce chapter is to promote electronic commerce among the parties in the wider use of electronic commerce globally. So it's more of promoting e-commerce, because e-commerce back then was not really as booming as now, that it is becoming the new norm when people are shopping online, and also to contribute the creation of environment of trust and confidence in the use of electronic commerce. By that, it means the legal and regulatory infrastructure should be in place to make sure that e-commerce growth is protected and all the businesses are facilitated by laws and regulations. And the third objective is to enhance cooperation among parties regarding the development of electronic commerce. We know that not all the parties have the same level of development in e-commerce. So cooperation is also among the primary goal of having the e-commerce chapter. So having that harmonization of laws, regulations, and protections, as well as the facilities, the end goal is, of course, to have a regional market integration. So having a harmonized rules across the 15 parties will enable market integration. So that is the end goal. As with the IP chapter, this is also influenced and modeled after the CPTPP, the Comprehensive Progressive Agreement for Transatlantic Partnership, where Australia, Brunei, Malaysia, New Zealand, Singapore, and Vietnam are parties of CPTPP. So most of the articles in the chapter is really similar to CPTPP. So we model after it. So because the CPTPP was signed not long before the RCEP negotiations start. And later, it was called e-commerce, but now people are saying, is e-commerce the only thing? And now the trend is that it becomes the so-called digital economic partnership, for example, between AMS and, for example, Singapore and New Zealand and Australia and so forth. So it's expanding. It's no longer just e-commerce, but it's digital trade. So digital economic partnership agreement is becoming the term that is going to be used in future FTA. I'd like to share the news that ASEAN agreement on e-commerce, ASEAN-owned e-commerce agreement, entered into force on December 2nd this year, after the ratification by Indonesia a few days before. So the e-commerce agreement is been entered into force, but the growth of e-commerce in the region is going so fast that the agreement may not be catching up. For example, the Google, Temasek, and Bain reported just recently that e-commerce gross merchandise value this year could exceed 120 billion by the end of 2021, a near doubling from 2020. And the potential is to reach 234 billion by 2025. So e-commerce is already booming. Well, our regional agreement is just entered into force. So that is because the private sector knows how to self-regulate. All the industries come up with mechanisms that eventually has the same effect of protection of consumers, ensuring that there is no fraud, and also some other mechanisms that are developed or put in place by the industry, as well as the literacy of the internet users, mostly young internet savvy citizens of ASEAN, and that really helped protect themselves from potential risk. And so I think there is an issue that e-commerce chapters or economic partnership chapters will have to take into consideration, that if we are very slow, we delay things while the industry is moving very fast, we will not be relevant anymore. So among the rules that are being agreed is the paperless trading. Of course, we want e-commerce that are paperless to also allow trade facilitations, custom processing to be electronically done through paperless. The recognition of electronic documents as a legal document is one of the rule. And then there is usually is followed by electronic authentication and electronic signatures. These are the mechanism to authenticate identity as well as documents. So this is two articles that always go together, because these are the mechanisms. And what we want is to have a technology neutral mechanism where parties can decide what mechanisms that they use based on their needs, and as long as they can prove it, the legality, then it is acceptable. And also online consumer protection. So because we don't see meet with the customers and the merchants, there need to be mechanism to protect them from any potential fraud, and also to recognize the importance of cooperation between consumer protection authorities among the parties, because this is how we resolve a cross-border dispute usually. And then another rule is becoming very important now is in the online personal information protection. Everybody is concerned about privacy, data privacy. In the EU has GDPR, the APEC have CDPR, and now China has developed their own personal data protection. They don't want their citizen personal data to be traded or to be exchanged outside their jurisdictions and all that. So this is becoming a very important areas that needs to be enhanced or improved further with the development of new mechanisms, cross-border data with trust, and this trust mechanism needs to be incorporated in the future FTAs. And then unsolicited commercial electronic messages, where you don't want people to send us advertisement to our mobile, although they do, but we know how to ignore them because we are more literate. But this is a rule that prevent the flooding of advertisement by allowing users to opt out, to say stop sending me, and also require consent when business sending any advertisement. Also, there is a domestic regulatory framework. This is the usual one because laws in digital trade is modeled after UNCITRAL. UNCITRAL has been developing many model laws on e-commerce, on international contracts, and now on model law on electronic transferable records. And so this is becoming important because all parties' laws will have to align with this, because that will enable more paperless transactions to be conducted. And sensitive one is custom duties. This is also in CPTPP, where transmission of product, for example, we buy software through internet on the internet and so forth. Custom duties should not be applied, but ASEAN has the position that we will follow the moratorium of WTO that has been put in place since the 2017 ministerial conference in 2017, and none of the 15 parties have imposed any custom duties on electronically transmitted products. We also have on cybersecurity, mostly in capacity building and cooperation, and two other sensitive articles is on the location of computing facilities. Some countries, mostly in Asia, want businesses that operate in our jurisdiction to have local presence. So all the computing facilities will have to be within the jurisdiction. So it cannot be outside the jurisdiction, so that data, citizen data residing on those facilities cannot be seized by other jurisdictions, authority, and other things. So this is the argument by China on the sovereignty, call it the data sovereignty, and also some countries in ASEAN that having data or server outside the jurisdiction may have some risk. But also there are some mechanisms that can be, can be developed to get around that by some MOUs and other things that can be put in place. But usually parties, they don't really want to take any risk. So this is, but eventually 15 parties agree that computing facilities can be outside except for protection of essential security interest by a party. So that is the carve out for location. And another one is cross-border transfer of information by electronic means, especially the personal data. So that is the most sensitive one. I think it's still ongoing, the issue of cross-border data, of cross-border transfer of data by electronic means. And again, the parties, Rsap parties agreed on the article with some carve out to exclude measures for the protection of essential security interests and other things. And lastly, there is a dialogue, which is actually a built-in agenda for the expansion of the Rsap, because some of the articles were rejected during the course of the negotiation. So it's now put in the dialogue where it will be will be discussed among parties whether it is worth incorporating in the Rsap. And last but not least, the settlement of disputes. The ASEAN doesn't agree to have this chapter subjected to the dispute settlement mechanism of Rsap. So, but this is a temporary. It was agreed that it will be reviewed during the Rsap general review and see what are the scopes where a dispute settlement can be effectively applied to ensure certainty for businesses, so that the provisions will become useful for the development of the digital economy. I think that's all that I have. Hopefully that provides some general structure of the chapter, and thank you again for listening.
All right, thank you very much, Mr. Budi. Moving on to the next part of the program, we have a panel discussion. For this session, I'd like to invite Mr. Keung Batran. He's the head of the Trade Facilitation Division of the ASEAN Secretariat. Mr. Keung will be our moderator for the panel discussion. You may take over now, Mr. Keung.
Thank you very much, Presti. Could you hear me clearly? Hello, can you hear me?
Yes, clearly, Pak.
Okay, thank you very much, Presti, and good afternoon, everyone. And luckily today we have all people in the almost same time zone, so we don't have to say good morning, good evening to everyone. All right, so shall we start for the panel discussion today? We are going to invite Mr. Hideyasu Tamura. Mr. Tamura is a Senior Director for Economic Partnership and Regional integration from Ministry of Economy, Trade and Industry from Japan. So Mr. Tamura is a very experienced negotiator before, and he also joined so many other positions before he became the Senior Director of MITI. Mr. Tamura, please, may I see Mr. Tamura?
Yeah, this is Tamura, and thank you very much. And hi, good to see you again.
Good to see you again.
Yeah,
Tamura,
and sorry, I don't know why my face is appearing as a kind of black and white kind of color, but I'm a kind of ordinary man, so I don't know why. Maybe this is a kind of system trouble. And thank you very much for inviting me to the this very valuable webinar. And so I think the theme I have to talk is on the kind of merit of the investment chapter of this agreement first. And yeah, so actually Japan.
Mr. Tamura, before you take the floor, can I invite two more
okay, sorry.
panelists? Sorry.
Okay.
Thank you, Tamura. And the second panelist, I would like to invite Mr. Edmund Sim. Mr. Edmund is an international trade lawyer from Upton Law. Mr. Edmund, please. Could you please turn on?
Yes, thank you very much for inviting me. Ironically, I'm probably the only non-RCEP citizen in this panel because I'm actually an American. So we don't do any FTAs.
Okay.
And I'm calling you from Washington, D.C.
Okay.
So it's morning my time. So thank you very much for inviting me to participate.
Good morning, Mr. Edmund. So now it's maybe 3 a.m. in the morning in Washington, D.C. So very early. But anyway, now we have a person from very different time zones. So welcome, Mr. Edmund. And the third panelist, I would like to invite Mr. Donny Ariata, Head of Public Policy South Asia, and Russia from Kuaishou Technology. Mr. Donny, please.
Hello, good afternoon. I am based in Jakarta, Indonesia. It's a pleasure to be here and looking forward to the lively discussion.
Thank you very much, Mr. Donny. So now the panel, we have 3 persons. We have so the session we focus on very insightful discussion on the commitment and the RCEP agreement. Basically, we try to focus on 3 chapters: investment, IP, and e-commerce, which already presented by our 3 distinguished speakers earlier. And under this session, yes, of course, we have various people from various backgrounds. We have some RCEP former negotiator. We also had some people from law firm, some people from government official who already joined some negotiation before, and private sector representative. So I think very diverse and various people, we may have different views. That's really insightful and interesting discussion. I just want to inform everyone about the rule for the discussion in the panelists. So panel discussion we will led by moderator Mr. B, and panelists will be put the question, and hopefully we can have some very good discussion. So with that, I think we are ready for the discussion with the panelists. Any questions before I proceed with my question to panelists? I see none. Okay. So I think the first question is for Mr. Tamura. It's about the investment chapter, and I think investment chapter in RCEP agreement is something really interesting. And thank you very much, Governor Marjorie. Marjorie actually is my co-negotiator. She already chaired investment group when I left the group. So thank you very much, Marjorie. And through the presentation by Marjorie, we see that how ambitious of investment chapter and RCEP agreement. And we see that now ASEAN, we can have some very good deliverable from this agreement by following the negative approach with 2 annexes and with some very substantial provision like amendment, PPR, standstill commitment, so on and so forth. So based on the presentation from Marjorie, we see that investment chapter under RCEP agreement could contribute a lot to business in ASEAN and also the partners. So may I ask a question to Mr. Tamura? How will investment chapter under RCEP agreement contribute to investment from other partners, particularly from Japan? So what you expect or how Japan and other partners could benefit from this investment chapter under RCEP agreement? We understand that before RCEP agreement, we already had some bilateral investment agreement concluded by Japan with some ASEAN country. And yes, of course, you also did something with some dialogue partners, for example, with Australia or some other country. However, now we have RCEP agreement, which is going to be effective next year for January. So again, how will investment chapter under RCEP agreement contribute to investment from Japan and also other partners? What do you expect next year? Thank you. Mr. Tamura, floor is yours.
Yeah, thank you very much, Mr. Kwon and also Marjorie. And yes, as you pointed out correctly, Japan already has a kind of, investment treaty or chapters vis-a-vis all RCEP participating countries, either in the form of a regional FTA like HSF or CPTPP, or bilateral investment treaty or investment chapters in the EPA, or even amongst China, South Korea, and Japan, we have a kind of trilateral investment treaty. And so basically, just considering those kind of existing agreements or chapters, just looking that kind of a shape, there might be no merit from RCEP, but that's incorrect. And we have significant merit from RCEP investment chapter. And one particular or characteristic issue is kind of, of course, prohibition performance requirement, PPR. And especially what our industries welcomed as a result of the negotiated outcome of the RCEP is the prohibition of the technology transfer requirement. Yeah, and in the last year, when just 1 year ago, when RCEP was signed and the full provisions of the agreement became public, several Japanese business associations issued a kind of welcoming statement for the RCEP agreement. And one of them from Japan Chemical Industries Association was on the welcome message on the PPR, especially prohibition of the performance requirement, prohibition of the technology transfer requirement, because Japanese material industries invest huge to RCEP countries, and but up to now, under several agreements, like say, including the China, Japan, Korea Trilateral Investment Treaty, or HSF investment chapter, or several other bilateral investment treaties, there were no specific provisions to prohibit the government authorities to on the technology transfer requirement. And of course, I have to admit there is a kind of reservation by each of the RCEP participating countries. But even with this kind of reservation, the principle of the prohibition of the performance requirement, especially technology transfer requirement, is quite huge to Japanese, quite huge or significant to Japanese investors in light of the providing quite secure regional investment environment. And that's quite a big merit. Of course, in addition to that, there are so many merits in the RCEP agreement, but that's one of the most characteristics merit of the RCEP. That's my initial response. Thank you very much, Kon.
Thank you very much, Mr. Tamura, for sharing your insight. I think one of the very great advantage what you already mentioned earlier is actually 15 party already reached some kinds of principal agreement that you already have the provision there. And what you need to do now, maybe in the future, is perhaps you can further deepen the negotiation for further liberalizing the annexes. So actually, if you all have the principle, it's very easy. So the rest of the work is you just further deepen the liberalization of the annexes. So that's something very successful, the RCEP agreement, and that's quite future-looking agreement in this case. And I think that's very positive signal for investor across the regions. So on this one, just want to follow up with what you already provided responses. So to further boost investment from Japan, also from other RCEP RPC. So which area under investment chapter you think maybe in the future, I don't want to foresee how many years, but maybe in the future RPC could consider to further enhance investment chapter to make it more comprehensive and make it more deepen and can attract more investor to the regions. So what do you think about this matter?
Yeah, thank you very much. So of course, as I said, there could be huge merit from the agreeing from the outset, but in addition to that, of course, we have to we wish to see further, developments or progress towards the future. And one of them could be, of course, from my personal viewpoint, like I said, there could be some, additional elements for the prohibition on the performance requirements. Like say, for several countries, in light of their development phase, they are not taking substantive commitment, either, especially on the prohibition of the loyalty rate, loyalty. So if that could be further improved by several participating countries, that could be quite appreciated. And also in some other agreements, previous agreements, which Japan already as a kind of member, there are several other elements for the performance requirement prohibition. And like say, that could be one of them could be like say prohibition on the requirement to set up a kind of research and development hub in the as a kind of condition for the investment. And of course, Japanese companies are quite keen to develop their research and development facilities or bases in Asia countries, including many other countries, but it should not be forced, and it should be a kind of choice by the private company. And so from the viewpoint of enhancing regional operation, the kind of further elements could be added. And also one important issue is, of course, ISDS, and it's a kind of work program. And in several years ago, at the ministerial level, there was a huge debate over how RCEP countries could handle or manage this issue. And of course, the detailed discussions should be kept confidential. And we all negotiators concerned have to bring that secret to grave. But anyway, that kind of elements could be the further subject for the further discussion. And after the entry into force, we wish to commence that kind of discussion in as a kind of package for the built-in agenda or work program. Thank you.
Thank you, Mr. Tamura. I think yes, of course, we can expect a lot more in the future. Yeah, but actually, so far, if we see that from the presentation by Manjari, we see that ASEAN country and also RPC from RCEP agreement, we already reached very huge leaps forward on this one, and we expect that when RCEP become effective next year, more investor from DP, from ASEAN, and also from Japan your country can be attracted by this agreement. And hopefully, particularly during this COVID-19 time when lots of investors suffer from some difficulty, such RCEP agreement could be some kind of incentive, could be a very positive signal to boost the economy in the region, and they can attract more capital, more investment from other region to RCEP region. And by doing that way, we can mitigate the negative impact of COVID-19. And hopefully in the future, we can continue to look forward where the area we need to further improve together and bring benefit could be like a mutually acceptable to all party, benefit to all party. So thank you very much, Mr. Tamura. I come back to you later. I think another area is the IP. That's very interesting. And I see the presentation from Elizabeth. Elizabeth, also my colleague a long time before, we did many negotiating together from TPP to RCEP and some plus on FTAs. Thank you very much, Elizabeth, for presentation. And we see that when you make the comparison between RCEP and TPP, we see very little gap between the two agreements. So this means that RCEP is really ambitious. And if we can compare with +1 FTA concluded by ASEAN before, we see RCEP is something very huge step forward compared to +1 FTA. And of course, we're very happy with this achievement achieved by 15 parties. So my question to Donnie, whether anything in IP chapter will be a very great value to business community according to your views. So please share with us which provision or which area you see that it can bring more investment into ASEAN and can boost more economy. Thank you very much. Donnie, please.
All right, thank you. So I'll add a bit to my introduction. So I am from Kuaishou Technology. It is a tech platform. It has gone public in the Hong Kong Stock Exchange earlier this year. So I hope to be able to add a little bit more of private sector perspective of what we see, how we see Rsap, and how we hope to be able to gain from this agreement. Yeah, so to answer your question specifically on IP, I think it's fundamental, and I think it's important that there is a recognition that it's an important and fundamental element that will enable trade. I think we heard earlier from Elizabeth that, you know, with the development of technology, there are so many different areas that touch upon IP that may not have been covered in the previous agreement before. So in particular for tech platforms, this is, I think we appreciate the recognition of the importance of IP, especially in these different innovations that is already going on in the tech sector. But more generally, I think on Rsap as a whole, what I see is from conversation with my peers from other companies, the general sentiment is positive and welcoming. I think it's when it was agreed last year, as the biggest multilateral trade agreement, I think it was really, we really looking forward to that. There's a little bit of anticipation on how the member countries will ratify this and implement this. And for Kuaishou, especially because we are in China, we are among the biggest e-commerce platforms, specifically live commerce. So we also look into the e-commerce provisions a lot, and there are some areas where we particularly appreciate. So the location of the computing facilities, as mentioned by Pak Budi earlier, that it was recognized it should not be in a particular territory. I think that's very important for tech companies. And the recognition that cross-border transfer of information should not be prevented. And the last point about the importance of dialogue, right, in promoting development and use of e-commerce. So we look forward to be part of this dialogue from the private sector. We look forward to the opportunities to provide inputs. We know that there are opportunities to expand Rsap or even to update it in the future. So, starting with forum like this, hopefully it will continue in the future. So yeah, that's a little bit of the private sector sentiment towards Rsap.
Thank you very much, Donnie, for your sharing. So we see that very positive response from private sector on RCEP agreement, and hopefully, if you need any further assistance from government side and also anything you need to clarify, please feel free to contact us and discuss more with us on e-commerce, IP, or investment. I think now is the time for me to turn to Edmund Sim. And I think IP chapter is something really ambitious under RCEP agreement and very comprehensive. So may I seek your view, whether you can share something with us. How do you view on RCEP IP chapter, whether this chapter would help to expand more business in the region, because now investors and businessmen, they feel that their intelligence, their property will be stronger protected by IP chapter and RCEP agreement. So they have a stronger legal framework and they can feel stronger enforcement under this plan. So how do you view this? And do you expect that there's booming investment under RCEP agreement with the new chapter IP?
Thanks for the question. I think IP is misunderstood, as Elizabeth brought up. I think a lot of folks wrongly view IP law, IP regulation as benefiting the big rich companies, the big rich countries. You could see this like when I lived in Singapore for almost 20 years. When I first moved to Singapore, there were black market CD-ROM sales of software a block away from the Ministry of Trade and Industry, and there was attitude, that if we buy licensed software, we only make Bill Gates richer. But then after being educated, properly about why IP benefits not just big companies, but also small companies, there was a change in the attitude of the Singapore government. And now we see that Singapore is one of the leading lights in IP technology, IP regulation. And so Singapore has reached a lot of the benefits of investment from all countries and so I think having a stronger IP protection system in RCEP is like giving oxygen to the operating system, to the bloodstream of RCEP. Yes, without IP, we could trade like lower level, less value-added goods. But IP is the value-added. So having stronger IP gives sellers the confidence that when they sell something, when they sell a product that has a special technology, or when they're selling software or other services, that they're protected. It benefits the buyer, because when they buy something which says, that has a special mark or special copyright, that it's authentic. You're not buying something that has been, made in the back of a warehouse, in some industrial district. It's actually being made by the real seller. So it benefits them. And then the final part about benefiting everyone, I'll give you a short story. There again from Singapore, there was a company from the United States was trying to sell technology to tint the windows of cars. Okay, they had the technology, and they went around to several stops around Singapore with a taxi driver, and they would discuss, the two guys from America would discuss this and what the technology involved. And they, after 4 or 5 stops, they didn't have anyone interested. So at the end of the trip, the taxi driver then asked, wow, you sound like you have a great product. Why don't you sell me the right to make this product in Singapore? Now that company is called VCool, and the taxi driver and his family is very, very wealthy. So that's a sign of how IP can benefit not just big companies, but also small companies. And so that's why IP in the RCEP agreement is very important, because it gives confidence to all parties involved in the transaction that their value added will be protected.
Thank you very much, Edmund, for sharing your views. Yes, I fully agree with your points. IP chapter could bring benefit to everyone, from seller to buyer, because the buyer now, they can buy the genuine product. They're not afraid of buying the fake one. And of course, the seller, they feel very protected. So they feel very confident when they put money into the market, and they will produce something, bring a very good value to the society. And of course, in overall, it can benefit the whole society, the economy in this one. And it can, of course, bring some very positive impact to the whole agreement, as well to all stakeholders in benefiting from this agreement. I think the next area very important is the e-commerce chapter. And thank you very much, Pak Woody, for sharing your views and some insight on e-commerce chapter. That's really important, particularly now ASEAN and also the partners, we're moving toward a very digital society. We call as a digital economy. We can call digital trade, trade digitalization, so many things about that. And recently we see that ASEAN just endorsed the Mandatory Bega One roadmap, which contains lots of trade digital economy agenda. And this really coincides with the entry into force of ASEAN e-commerce agreement. So at the same time, we have some very good agreement become effective in the very near time. So in this one, coming back to the RCEP e-commerce chapter, we see that under Article 12.15 about data free flow. So under this article, even there is some exemption article such as legitimate public policy objective, and it considers necessary for protection of its essential security interests. So why is the data free flow very important to RCEP? And in addition, how should this exemption article be implemented after the entry into force of RCEP agreement? So I think the question I would like to address to Mr. Tamura first, and yes, of course, other panelists, you have any other input to share or to add, so please feel free to discuss on this one. Mr. Tamura, please.
Yeah, thank you very much. And yes, on this e-commerce chapter, and especially on the some data related to provisions, like say data free flow principle and the principle for the prohibition of the data localization or computing facility placement requirement. For these provisions, especially have a kind of quite long history, and so huge debate were made amongst the negotiators. And it is because these areas were quite new to several countries, and also, like say, there's some sort of precedent as a kind of in the form of the TPP e-commerce chapter, and but it seems several countries had a difficulty in incorporating the CPTPP provisions as it is, and RCEP Agreement e-commerce chapter. So there's a huge debate, and but even after those kind of huge debate, we came up this agreement. And yes, of course, you are quite right that we have kind of public policy objective and the essential security interests, those kind of some sort of exception. And the scope should be kind of issue while RCEP agreement was examined in the Japanese National Diet. So of course we have to make some improvement for the future, but even with that kind of exceptions in light of the essential security interest and legitimate public policy objective, the principle of this article is quite important. Like say, those measures should not be in the form of the undisguised trade restriction. So, more in a more general words, these measures should not be taken in a kind of more restrictive manner, quite unnecessarily restrictive manner to business operations. That kind of fundamental principle is quite important. And from now on, after the entry into force, what we might have to ask all RCEP participating countries or RCEP parties is not to say, just say, okay, we have that kind of exception, so we can do anything. I don't think that's a kind of correct behavior, but respect the fundamental principle of the, not to be too excessively restrictive to businesses while protecting the legitimate public policy objective or essential security interests. That kind of behavior could be quite appropriate for all parties. And in that regard, of course, I don't point to the name of several countries, but I have a concern that in several countries, even at this juncture, taking some sort of a bit restrictive measures in their recent domestic, legal enactment or some amendment of the existing regulations. So I wish all parties after the entry into force to, respect the basic principle of the RCEP Ecommerce chapter and behave in that kind of way. Of course, it's just including Japan. That's my personal viewpoint. Thank you very much.
Thank you, Mr. Tamura, for sharing a very insightful idea on this matter. May I say whether Mr. Donny or Mr. Edmund, you want to share anything about this question? Because the question is quite interesting, particularly for Mr. Donny, because this one quite related to the technology issue where you are working in that sector.
Sure.
Donny, please.
Yeah, thank you. So I think, first of all, like I've shared before, we really appreciate from the private sector the recognition that free flow transfer of data is recognized in the Rsap. And second, I think when it comes to the flow of data, the ultimate question is, can we really prevent it from happening, right? So Pak Budi has said about the agreements and government regulation playing catch up to the development of the industry. And I think this is a particular area where it's really prominent. So this article, which I think relates very much with the article about the computing facility where it needs to be located, there are some, some regulation that requires for data, certain data to be onshore as a requirement for investment of a company. I think there's a little bit of misconception on how data flow works. It does, because it's not a physical thing, right? It doesn't mean that when you have a data center, then a particular government can just knock to that data center and ask for data. It doesn't work that way, right? So sometimes I feel the restrictions are, it may not be as effective as we wish. So might as well because the trend is there will be more and more data flow between various countries, between different territories. So I think it's we really appreciate that Rsap recognizes this.
Thank you very much, Mr. Donny. That's really insightful sharing. And yes, we recognize the views from the private sector. That's very important because actually all agreements negotiated is just for the ultimate purpose to service the private sector. So whether Mr. Edmund want to share anything on this article?
Well, I would note that, as was noted by the speaker from ASEAN Secretariat, that dispute settlement does not cover, the agreement doesn't cover the e-commerce. But, and so if you're like, frankly, typical Western style lawyer, you view this as a weakness. However, that overlooks the local conditions, the local cultural and regulatory conditions in the Rcep region. Not everything goes to goes to litigation or arbitration. Like in ASEAN itself, the EDSM has never been used. So, but that doesn't mean it's not useful. It is the potential. Okay, in physics, you have actual energy, you have potential energy, and so it's the potential that provides support and reassurance to industry actors. So with regard to e-commerce, yes, there's no dispute settlement there, but there is the potential dialogue. Frankly, given how long it takes to go to the dispute settlement, the value is important, but more important is dialogue. More important is having conversations with other governments and with the industry. And I think that's so that's where the implementation, the compliance is going to be very important, because fundamentally, the data stream is that it's a stream. It's not a pool. It's not a big tank where you keep all the data. It's always running around, as Baghdani was talking about. And so, I think there has to be, in terms of the regulation, also a continuous flow of information and views for it to operate properly.
Yes, thank you very much, Mr. Edmund. So that's something to live for desire in the future. Yes, of course, if we have a chance to upgrade further the e-commerce chapter. So I think exactly that's the point I want to follow up the question on this point. Actually, I intend to ask the question, so what are the challenges in the e-commerce business that need to be addressed? But even with the new e-commerce chapter and the RCEP agreement, it had yet addressed such concern or challenges for the business in the regions. So I just want to ask this question to see whether any room for us to further improve the RCEP agreement. Yes, of course, it just it will become effective soon next year, but I think for the future we need to see something in the cycle of next 5 years or 10 years to see whether any room further improve. If you know that, as I already mentioned earlier, now ASEAN already just endorsed the mandatory Bega 1 roadmap. And yes, of course, we need to see what the interest, what the demand, what the challenges, the private sector in the region, and of course, from the DP country, they expect from the government to do something to help them. So perhaps we need to get viewed through some kinds of dialogue or roundtable discussion like that to see how they expect more for e-commerce in the region, because now everything, everywhere, every people is talking about e-commerce. So with the new chapter on e-commerce under RCEP, we would like to see the sharing from your side, whether any issue need to be further addressed and whether e-commerce chapter need to be further upgraded to address such concern. So I think I can give floor this time to Mr. Edmund first to continue beside what you already shared to us about the EDSM things or some other thing, and we can move round to other partners.
Well, thank you. I think there are a couple of points touch on briefly and let others speak. First of all is the interaction of the e-commerce chapter with other chapters. So, for example, competition. That's a big issue, is because, frankly, globally, a lot of e-commerce is handled by very large companies based in the United States. So I think we have to have some sort of understanding of how the competition rules, the aspirations of competition rules in the RCEP will interact with the e-commerce section. The second thing, and I think this is something maybe not necessarily for amending the agreement, but in terms of understanding the principles of how they apply, because how do they apply to new technology? So when you concluded this agreement, there was Facebook was still called Facebook. Yeah. Now it's called Meta. Okay, yeah. And so basically, we have to have ideas like, what does it mean? What happened? What does it mean? Like, you conclude a contract in the Meta world, right? If your avatar makes a contract with what if you have a dispute about virtual coins? Like my children spend lots of money buying artificial coins in Fortnite, right? What if you have what's the law on theft? Someone going in with in the Fortnite game and hacking it and stealing all your coins. So these are all things where, again, do I expect the RCEP agreement to have some sort of provision saying, for virtual currency or and that, for example, crypto, that's another one. So that interacts with financial services. So that goes back to my first point. So I don't expect this to be handled in terms of text. I think what needs to be done is in implementation to adopt best practices and to have dialogue, not just with the governments, but with the private sector, and in particular with the tech companies.
Thank you very much, Mr. Edmund. That's perfect and fantastic. Yeah. We need to learn more best practice around the world and to see what we can learn from them and what can be applied in the regions. So whether Mr. Tamura or Donny will have any answer or respond on what I addressed to Mr. Edmund before.
I think I can quickly add a couple of issues that maybe we can consider when it comes to e-commerce. So one is AI, which is a really important element. So it's more on the ethics of AI, right? On working together in developing ethical principles and standards for AI and more generally emerging technologies, like Edmund has said. And second, I think the area around the support to SMEs, small and medium enterprise, because they constitute a large part of the e-commerce trade. And how are we going to support this, aside from the big companies as well? One way is promoting interoperability of different transaction modules. So these are some of the issues that are probably not much covered in the RCEP, but they are being discussed in other digital trade agreements. So maybe that's what we can start with.
Yes, that's correct, Mr. Donny. I fully agree with what you share. If we look into some other e-commerce agreement, for example, between Singapore and Australia, we see some very advanced provision on this one, particularly for the e-signature, paperless trading, and so on and so forth. So we see a lot of trend development on digital economy. So particularly for ASEAN now, we also eyeing to digital economy by further looking into the issue of interoperability with some initiative now ongoing in the region, for example, like ASEAN Single Windows. That's perfect and fantastic for us to look forward. And of course, we also see that from the private perspective, they're also developing some private platform to exchange some digital documents, and that would lead to some demand and interest to integrate both platforms just to reduce the cost of transaction, reduce the time, and I think that should be covered under e-commerce. And this could be very critical agenda for ASEAN and also our partner to look for the future agreements. So something that we need to check. I think we only have 2 more minutes before we reach 4:10. So I think I don't need to ask any more questions, because if one more question, it may go beyond the time allowed by the organizers. So I think just the last point I want to share with everyone. So with the RCEP agreement, I think we have 20 chapters in this agreement. This is one of the most comprehensive agreements signed by ASEAN member states with together collectively with our partner. And I think yes, of course, still many things desired to be expected in the future. But I think at this juncture, with the entry in force agreement, businessmen, private sector in the region, we could expect a bright future for the next year, and hopefully RCEP agreement entry in force could help business in the region to combat the COVID-19 and provide more trade facilitation. You see that lots of lots of provision under RCEP agreement, including the IP, investment, commerce, and so on and so forth, could contribute very much and add lots of value to the trade facilitation, e-com, and everything in other sector. So let me conclude the section of panel discussion today by thanking to all 3 panelists for your excellent discussion and intervention. Really appreciate for that, and hopefully we may have next chance to further discuss and deepen the understanding on those specific sectors. Thank you very much, and enjoy your time. And back to you, Presti. Thank you very much.
Yeah,
Thank you very much. Thank you to all speakers for your very insightful discussions, and Pak Keung for moderating the session. We can now understand better on some areas in the investment chapter which could be further enhanced, and that intellectual property would not only benefit big companies, but more importantly, small and medium-sized companies, and that there are some areas in e-commerce chapter that need to be regulated, such as data flow, data privacy, artificial intelligence, and etc. So this webinar is coming to an end, but this is definitely not the last part of our RCEP webinar series. We will have the 5th RCEP webinar next week on 16 December 2021, same day, same time. And I would like to also thank everyone who has spent their time to join today's webinar. We greatly appreciate your participation. So thank you very much. And if you want to rewatch today's webinar, it will be available in the ASEAN Secretariat YouTube channel. So I'm looking forward to seeing you all to the next webinar. This has been your host, Presti, reminding everyone to keep safe and stay healthy. Thank you very much.
Thank you.
Thank you very much.
Thank you.
Thank you.
Look forward to the entry into force.